I must express to you my gratitude that you came tonight. We look forward to your participating in further events of the Mormon Studies program at the University of Virginia. So thank you for coming. We like to make new friends. There are many people I need to thank, and I will thank them personally afterwards, but I would like to recognize the UVA Alumni Association out there, folks. Hi, really glad to have you here. And also representatives from the Church of Jesus Christ of Latter-day Saints. Some of their leadership have taken the time to join us. I won't impose upon them the burden of any official visit, so I just want to acknowledge that we're grateful to have them here. And also from the local stakes and congregation around DC, and just friends and admirers of Professor Laycock, as am I. So thank you for coming. And to all those who staff this event, Spencer Wells, where are you, Spencer? He's out doing something. This is the man. If you have any complaints, that's the man too. But he's done a wonderful job tonight. I thank him very, very much. So let me get started with what you came for. I want to remind you of a phrase you've all heard: pick my pocket, break my leg. It's what Thomas Jefferson established as his bright line test for the limits of religious liberty. Whether a person believes in one God or many gods does not pick my pocket or break my leg. But what of other harms? Harms to dignity or to free access to markets or other goods and services? What would Jefferson say to that? We don't know, and we cannot know. He's no longer with us, but we do have another sage from his beloved university to try to answer that question, or at least illuminate it. I don't want to put the burden on him to answer it, but to illuminate that question in a way that might bring us some peace. So I am grateful to him for accepting my invitation to speak, and so grateful that I'm going to give him the honor of being introduced by our mutual friend, Christine M. Durham. She is the former Chief Justice of the Utah State Supreme Court and currently President of the Conference of the Chief Justices of the United States. I invited her to do this not merely because of her status, but because of her sagacity in helping us appreciate what we are about to hear from Professor Laycock. Justice Durham.
Thank you very much, Kathleen. A number of people have essentially said to me this evening, what are you doing here? and in truth, I am, I think, presuming on longstanding association and work with Professor Laycock in our responsibilities as members of the Council of the American Law Institute, of which he is currently the second vice president, a very important position, and the fact that I have known Kathleen since she was in law school, so.
And I graduated.
And she graduated, that's right. It's a great pleasure to introduce Professor Laycock this evening, as I have admired his work and in my capacity as a state justice interpreting state constitutional religion clauses, among other things, relied upon that work. Professor Laycock is currently the Robert E. Scott, and I hope this is all current, Doug, you can correct it if it's not, Distinguished Professor of Law, the Horace Goldsmith Research Professor of Law, and a Professor of Religious Studies at the University of Virginia, where, as many of you probably know, his wife Teresa recently stepped down as president. I am also happy to share with you news that Professor Laycock shared with me this week, in that a long-term project of his is currently coming to fruition. And for any of you who need reading material on religious liberty for the rest of your lives, I direct you to a project that has collected his writings on religious liberty. Doug shared with me that it contains 4,800 pages, 5 volumes. And just in case you need specifics so you can pick which volume to start with, Volume 1 talks about overview and history. Volume 2, the free exercise clause. Volume 3, Religious Freedom Restoration Acts and Same-Sex Marriage. Volume 4, Federal Legislation and More on the Culture Wars. That'd be a great place to start. And then finally, Volume 5, Free Speech and the Establishment Clause. That is a major work. One of the remarkable things about Professor Laycock's scholarship and his work is that he doesn't take sides in the culture wars. He is for liberty with respect to religion for believers and non-believers alike. He believes in equal liberty for all where religion is concerned. He is both a theorist and an enormously pragmatic and practical lawyer, in that, in addition to his scholarly work, innumerable textbooks and law review articles, he has written, at least from my perspective, countless briefs on cases going before the federal and I think some of the state courts in the country, and certainly before the United States Supreme Court. One of the things that I think is fascinating and unusual in a lawyer, and this is perhaps the theorist and scholarly side of his work, he has never written a brief in a piece of litigation containing arguments or positions that he would not embrace in his scholarly writing. That means he doesn't write for the client, he writes for what he believes in about religious liberty. Of interest to some on this occasion, I think, is that he was recognized in 2012 with the Religious Liberty Award given by the International Center for Law and Religion at BYU. And I think you were introduced, or at least presented with the award by another Durham on that occasion, my husband's cousin Cole and my long-term friend. There's much more to his work besides simply religious liberty. He is an astonishingly prodigious producer. He's also nationally known for his work on remedies, on employment law and sex discrimination, on commercial law and bankruptcy. As I mentioned, he's the second vice president of the American Law Institute and a member of that body's council. And he's a fellow of the Academy of Arts and Sciences. I could go on for a long time, but I must conclude so he can talk to you. But I want to end with language that is not mine, but which is so apropos of this occasion that I'm just going to flat out steal it. And it's from a law review article that was written over a dozen years ago about the legacy of the work of Professor Laycock. So if you had to add, I don't know how many of those 4,800 words have been written in the last half dozen years, but it's not time to assess his legacy. Nonetheless, I think this is very effective language. Douglas Laycock is a towering figure in the law of religious liberty. He's been a path-breaking scholar, a successful appellate litigator, a legislative advocate instrumental in the development of statutes protecting religious liberty, and a commentator known for his ability to summarize church-state law and debates cogently and with sympathy for the conflicting sides. He has defended the rights of individuals and groups of almost every possible religious view, from evangelical Christians to Santeria animist worshipers to atheists. As a result, he is respected by people on both sides of the culture wars that animate many religious clause controversies. Please join me in welcoming Professor Laycock.
If I ever need a public affairs agent, I'll call Christine. That was mostly true, somewhat exaggerated. Let me just say about those 4,800 pages, it wasn't my idea, and we had no idea it was going to be 4,800 pages, but it was never anticipated that anyone would read them. It was anticipated that it would be a reference work, and maybe the greatest advantage of putting the collection together is it's all indexed now. It covers a lot of issues. It doesn't cover everything, but it gets around the field. So my title tonight is What the Supreme Court Did in Masterpiece Cakeshop. That's the case of the wedding baker who refused to make a cake for a same-sex wedding. And Kathleen Flake asked me for that title before the court had decided. We didn't know what was going to happen, so we wrote a title that would cover any eventuality. So what did they do? Probably nearly all of you know that the court held the baker to be protected. You may also know, or some of you may know, the decision has been widely described as a very narrow decision on an odd set of facts. The tenor of what I'm going to talk about tonight is that I think, in fact, it has much broader implications. The decision is not nearly so narrow as it's been described. Let me make my own position clear at the outset. Since same-sex marriage first became a prominent public issue in 2004, I have advocated for marriage equality with religious exemptions, full legal equality for same-sex marriages, with exemptions that protect religious organizations from having to celebrate or recognize those marriages, and with exemptions for very small for-profit businesses from having to assist with the wedding or its celebration, so long as other providers of the same goods and services are readily available. The solution to this conflict, as to so many others, is to protect the rights of each side, the right of both same-sex couples and conscience objectors to live their own lives by their own deepest values and in accord with their own deeply felt identity. And as I've explained elsewhere, they make fundamentally similar claims on the larger society. Government should not interfere with sexual orientation, and it should not interfere with the exercise of religion, except for the most compelling of reasons. The Masterpiece opinion does not go that far, but it is consistent with that view. The court set the right tone initially, speaking in Justice Kennedy's sometimes florid prose about the necessity to respect the rights and dignity of both sides. Now, for any deeper analysis of Masterpiece, or at least for my analysis of Masterpiece, to be comprehensible, I have to start in 1990 with Employment Division versus Smith. Smith changed the law of the free exercise of religion in important ways. 28 years later, the meaning of that change is still unsettled. Mr. Smith attended a worship service at the Native American church, where the central ritual is the consumption of peyote in a highly structured ceremony under the supervision of a peotero. Hallucinogenic drugs have actually been used for religious purposes around the world and throughout most of human history. Peyote is a naturally occurring hallucinogen. You consume peyote by eating the bud of a cactus plant. It is tough. It is hard. It is hard to chew. It generally makes you throw up before it makes you high. So there has never been much recreational market for peyote. But American Indians were using peyote for religious purposes when the earliest Spanish explorers arrived in the Southwest, and some of them still are. The Native American Church teaches total avoidance of all other drugs, including alcohol, and is generally viewed as a positive influence in the lives of its members. Religious use of peyote by American Indians has long been exempt from the federal drug laws by statute and by regulation. And after the court's decision, Congress protected it from state regulation as well. Smith was fired when his supervisor learned that he had attended a peyote service. He applied for unemployment compensation. The Supreme Court had repeatedly held that workers who lose their job for religious reasons, for refusing to work on the Sabbath most commonly, or for refusing to make weapons in one case, were entitled to unemployment compensation. The relevant legal rule came from two leading cases, Sherbert versus Verner and Wisconsin versus Yoder. Sherbert and Yoder held that government could not burden a religious practice unless that burden was necessary to serve a compelling government interest. So, to mention an actual example, government could refuse to exempt people who conscientiously objected to paying their taxes, but there was be a lot of converts in a hurry if that had come out the other way. There was no such compelling interest in withholding unemployment compensation from workers with religious practices that conflicted with their employer's demands. In Smith, the state claimed a compelling interest in a no-exceptions drug enforcement policy. Smith replied that the tightly controlled religious use of peyote was not dangerous to anybody, and so the state's interest was nowhere near compelling. And that is how the case was argued, but the Supreme Court did not resolve that disagreement. Instead, and without being asked, Justice Scalia said the state didn't have to show a compelling interest at all. The law was neutral and generally applicable, a phrase he never defined. It could be applied even to the central ritual of a religious worship service. The opinion appears to say that if the law is neutral and generally applicable, the state doesn't have to have any reason at all for refusing a religious exemption. It can just say no. Smith was 5-4. It was the work of 4 conservatives plus Justice Stevens. The rhetorical tone of the opinion was hostile to religious exemptions, and lower courts initially said that pretty much every law was neutral and generally applicable, even a zoning law that said no churches. The city had a reason for excluding churches that was not just hostility to churches, so according to the Court of Appeals, the law was neutral and generally applicable. But Sherbert and Yoder were not overruled. Scalia had only 5 votes, and it's a reasonable inference that one of those 5 said he wasn't willing to vote to overrule anything. So Sherbert and Yoder were distinguished and given new explanations. Yoder had held that Wisconsin could not require the Amish to send their children to high school. Scalia claimed that Yoder was based on a hybrid of free exercise and the parents' rights to control their children's education. This hybrid rights theory seemed to contemplate that if you combined a failed parental rights claim with a failed free exercise claim, the 2 failed claims together somehow add up to a valid hybrid claim. That never made any sense, and almost nothing has come of the hybrid rights theory. And by the way, Scalia had long claimed there was no such thing as parental rights, but he pulled it out for this occasion. The more important reinterpretation was what Scalia said about Sherbert versus Verner, the first of the unemployment compensation cases. He said that the law in Sherbert was not neutral and generally applicable because the state accepted, quote, at least some reasons for refusing available work. You don't forfeit unemployment compensation if you decline a job far beneath your skill level or 200 miles from your home. You don't have to work in a strip club or a massage parlor. There weren't many acceptable reasons for refusing work and demanding a government check instead, but there were some. And because the state accepted some secular reasons for refusing work, it had to also accept religious reasons. Mrs. Sherbert was still constitutionally entitled to her employment compensation even after Smith. The implications of that reasoning were initially concealed by the opinion's rhetoric, but think about it. If a law with even a few secular exceptions isn't neutral and generally applicable, then not many laws are. Exceptions grease the wheels for legislation. Legislators often exempt their friends and contributors, and they exempt interest groups that might be strong enough to block passage of the law. There were no exceptions in the law banning peyote, but such across-the-board total prohibitions are actually fairly unusual. Smith says that if a law that burdens religion is not neutral or not generally applicable, it still has to be justified by a compelling government interest. And his discussion of Sherbert versus Verner implies that not many laws are neutral and generally applicable. The court returned to the issue in 1993 in a case called Church of the Lukumi Babalu IA versus City of Hialeah. No justice attempted to pronounce the name of the case. Santeria is a Cuban religion that combines elements of Catholicism with elements of Yoruba religion from West Africa. Its central ritual is the sacrifice of small animals, mainly chickens and goats. There were an estimated 50,000 Santerians in South Florida, mostly practicing in secret. And when the Church of the Lukumi proposed to take the religion public, Hialeah passed 4 ordinances to prohibit animal sacrifice. They were drafted to ban Santeria services without affecting any of the other myriad reasons why humans kill animals. It was a crime to unnecessarily kill an animal in a ritual or ceremony, not for the primary purpose of food consumption. That narrowed it down pretty tight. The city said this was neutral and generally applicable because no one could sacrifice an animal, and the church did not get a single vote in the lower courts. The Supreme Court reversed 9-0. These ordinances were not neutral, they were not generally applicable, and the court said they didn't come close. The court discussed neutrality and general applicability separately. It still did not define either term. It discussed neutrality in terms of discrimination because of religion, which suggests perhaps bad motive or anti-religious motive, but no such language appeared in the section on general applicability. Instead, the court applied what amounted to a standard. The city had said that animal sacrifice undermined government interests in public health and in protecting animals, but the ordinances failed to regulate other activities that undermine those same interests to the same or greater extent. And not just other killings of animals, which was the most obvious analogy. The city's health officer admitted that the garbage dumpsters of restaurants were a bigger health hazard than the carcasses of sacrificed animals. But one was banned and the other was not, so the ban on sacrifice was not generally applicable. It was an element of the offense that the killing of the animal be unnecessary. And the city said that, of course, religious killings are unnecessary. They are unnecessary only if the religion is false, which is clearly what the city believed. But no American government gets to decide which religions are true and which are false. The Supreme Court didn't say that. It made a different point of potentially broader application. That when the city said that secular killings were necessary but religious killings were not, it devalued the religious reasons for killing animals, judging them to be of lesser import than the permitted secular reasons. So once again, if you take the court's reasoning seriously, many laws will fail the test of general applicability. Many laws that burden religion will still require compelling justification. Anytime the government prohibits a religious practice but exempts some analogous secular practice that undermines the same government interest, it decides that the secular practice is more important, more valuable, more something that makes it more deserving of an exemption than the religious practice. Government devalues the religious practice as compared to the secular analog. But on its facts, Lukumi was an extreme case. These ordinances were clearly enacted to suppress a particular religious practice. And government lawyers still today argue that every law is neutral and generally applicable, except for a few rare laws always enacted somewhere else that are as extreme as the ordinances in Lukumi. And a few lower courts have agreed with that, but more courts have concluded that even one or a few secular exemptions, if they undermine the interests the law is alleged to protect, show that the law is not generally applicable. So Newark had a rule that police officers must be clean-shaven, with a medical exception for officers with skin conditions that make it difficult to shave. That was it, only one relevant exception. But the Court of Appeals said that Newark had to also exempt Muslim officers with a religious obligation to grow a beard. Newark had made a value judgment that medical needs were more important than religious needs. And it was that value judgment that Smith and Lukumi forbid. The Newark opinion in the Third Circuit was written by a judge you may have heard of, Sam Alito. There are 9 or so similar decisions in lower courts around the country, which at last brings me back to Masterpiece Cakeshop. The question is going to be, was the law in Masterpiece Cakeshop neutral and generally applicable? Masterpiece is one of a handful of cases in where conservative Christians in the wedding business have refused to assist with a same-sex wedding and have been sued under state public accommodations law. These vendors generally understand marriage as an inherently religious relationship, and therefore they understand weddings as inherently religious events. Their job is to make their part of the wedding the best and most memorable it can be. They understand themselves to be promoting and celebrating the wedding and the marriage. Some of them have happily served longtime gay customers, but they say they cannot do the wedding. For them, it is a religious event that is religiously prohibited. It is a sacrilege, and they cannot participate. These cases have mostly been litigated under state law protections for religious liberty. They have all been in blue or purple states, because those are the only states with statewide gay rights laws. And the religious claimants all lost: a photographer in New Mexico, a baker in Oregon, a florist in Washington. Masterpiece arose in Colorado, which has no statute protecting religious practices from the state, and no state Supreme Court decision interpreting the Free Exercise Clause of the state constitution. So the federal claims and the federal defenses played a larger role in Masterpiece than they had in the earlier cases. The Masterpiece baker, Jack Phillips, claimed that his cakes were works of art protected by the Free Speech Clause. And if you look at the pictures of his cakes, that is not crazy. But it has no logical stopping point. If cake decorating is speech, lots of businesses can be characterized as speech. And at the oral argument, his lawyer was pressed to draw a line, and she had no coherent theory. She came close to saying that wedding cakes were uniquely speech and that nothing else would be covered by her proposed rule. But she couldn't explain why, and in another case, awaiting at the court at the same time, she was saying that flower arranging was speech. Phillips also had a federal free exercise claim, but for that, he had to show that the Colorado law was not neutral or that it was not generally applicable, and his lawyers obviously doubted whether they could show that. They gave much more attention to the free speech claim than to the free exercise claim. And I can tell you that no one sympathetic to the state and the same-sex couple took the free exercise theory the least bit seriously. a prominent law professor on a listserv that I'm not permitted to cite, said that the court would reject the free speech theory and then dispose of the free exercise theory in a paragraph. That widespread disdain for the free exercise claim, I think, resulted from the rhetoric of Employment Division versus Smith still dominating any close analysis of what the Smith and Lukumi opinions actually said. I have a frequent collaborator at St. Thomas University in Minneapolis, Tom Berg. Tom and I filed an amicus brief devoted solely to free exercise. And we argued for an exemption only for small businesses and only for events directly related to the wedding. This focus on the religious context would lead to a much narrower exemption than the free speech theory. Free speech theory would have protected simple bigots in all contexts, not just those with sincere religious objections and in religious contexts. The Colorado Public Accommodations Law had no explicit secular exceptions, but we said that it had been enforced in discriminatory ways that gave rise to an implicit secular exception, and that this secular exception meant that the law was not generally applicable. The court did not say that, but it relied on much of the same evidence to say something that led to nearly the same place. It said that the law was not neutral because Colorado's enforcement pattern showed hostility to religion. One of the civil rights commissioners had made hostile statements on the record, blaming religious liberty for slavery and the Holocaust and calling Jack Phillips's religious commitments despicable. Did you know y'all have done all that? Slavery and the Holocaust are all on us. Views of that sort are actually very widespread, but public officials have now been warned not to talk about them, and so those facts may not recur. The other evidence in the case is more important. A Christian activist named William Jack went to 3 different bakers requesting cakes with scriptural quotations hostile to same-sex marriage. Some of the messages were offensive. Each baker refused to make his cake. He charged him with religious discrimination, and the Civil Rights Commission dismissed the charges. Now, the same Colorado law that prohibits discrimination on the basis of sexual orientation also prohibits discrimination on the basis of any religious practice or belief. So the Colorado courts had to explain why it was that the Masterpiece baker, Jack Phillips, violated the statute and the other bakers didn't. And in the course of doing that, the Colorado Court of Appeals said some deeply inconsistent things. Most fundamentally, it said that refusing to make a cake with a message closely associated with same-sex couples discriminated on the basis of sexual orientation. But the refusing to make a cake with a message closely associated with conservative Christians did not discriminate on the basis of religion. For the protected bakers, the court assumed that the message would be the baker's message and not merely the customer's. The protected bakers, they said, could lawfully object to the offensive nature of the requested message. But for Jack Phillips, the court said that a wedding cake would send no message, but if it did send one, it would be the customer's message and not the baker's. The protected baker's willingness to produce cakes with other Christian themes for other Christian customers was treated as exonerating. Petitioner's willingness to produce other cakes and baked goods for same-sex couples was treated as irrelevant. For Jack Phillips, the fact that he would merely be complying with what the law required meant he would send no message. For the other bakers, that argument went unmentioned. The court also said that in the cases it distinguished, the protected bakers' cases, the customer wanted objectionable words and symbols on the cake, and that in Jack Phillips's discussion with a same-sex couple that sued him, they hadn't gotten that far. He did not learn what they wanted on their cake. That argument has been picked up very widely on the same-sex couple side of the debate. Some even claim there's a consensus that the baker could not be required to write any explicit message on a cake. There is no such consensus, and my own view is that this argument is deeply disingenuous. In the actual transaction, Phillips could surely assume that the couple wanted some words or symbols on the cake, and he had testified that an essential part of his task was to help them choose those words and symbols. And in any event, the very purpose of a wedding cake is to celebrate the wedding and the marriage with or without any inscription. As the Colorado court said, as it ruled against him, the couple asked Phillips to design and create a cake to celebrate their same-sex wedding. And under the rest of the Colorado court's reasoning, the case would have come out the same way, even if the conversation had lasted longer and the couple had said they wanted 2 men in tuxedos, or David Hart Charlie, or a rainbow, or any other more explicit message. the court's logic would still have said that it would be the customer's message, not the baker's, that Phillips would merely be doing what the law required, and that refusing to produce a message so closely associated with same-sex couples discriminated on the basis of sexual orientation. I do not believe for a minute that the Civil Rights Commission or the Colorado Court of Appeals would rule any differently in a case where the customers requested an explicit message. Most fundamentally, I don't believe it because if refusing a cake with an explicit message is protected, then the conscientiously objecting bakers win. All they have to do is know enough law to keep the conversation going and find out what they're supposed to put on the top of the cake. And when the chosen message, or when the message is chosen or revealed, they can say, oh, I'm sorry, I can't produce that message. Protecting explicit messages would not be so much help to florists or wedding photographers, but it would largely solve the problem for the bakers. And there's no reason to believe that the gay rights side of this debate would accept that answer. Even if the Colorado court's alleged distinctions were more persuasive, even if they succeeded in placing the two sets of bakers in different doctrinal categories under state law, that would not change the bottom line. The conscience of bakers who support same-sex marriage or refuse to oppose same-sex marriage is protected. The conscience of bakers who object to same-sex marriage is not protected. This discrimination is like the ordinance in a Supreme Court case from the early 90s, RAV versus City of St. Paul, where racial epithets were illegal, but racist, bigot, and a vast range of other offensive epithets were permitted. State law placed the two sets of epithets in different doctrinal categories. The correlation between the epithet hurled and the identity or viewpoint of the speaker was less than perfect, but these distinctions could not save a regime that effectively, the court said, licensed one side of the debate to fight freestyle while requiring the other to follow a Marquis of Queensberry rules. It is no more defensible for Colorado to allow one side to follow the dictates of conscience while requiring the other side to submit its conscience to the demands of any customer who walks in the door. The Supreme Court of the U.S. did not invoke RAV, and it did not rely on all the evidence I have outlined, but it relied on important parts of it. It noted the inconsistency about whether any message would be the baker's message or the customer's message, and the inconsistency about the baker's willingness to provide other goods and services to the protected class. And it focused on the Colorado court's statement that the protected bakers could refuse to provide the, quote, offensive message that William Jack had requested. And the Supreme Court said a principled rationale for the difference in treatment between these two instances cannot be based on the government's own assessment of offensiveness. Much of the commentary, as I said, has treated the court's decision as confined to an odd set of facts and as having avoided the underlying question of whether religious wedding vendors can be required to assist with same-sex weddings. But these facts are readily reproducible. Wedding vendors seeking exemptions can send testers like William Jack to request an offensively conservative religious version of the same goods or services, and we can confidently expect state enforcement officials to react just as they did in Colorado, protecting the conscience of the vendors they agree with, and perhaps refusing to protect the conscience of the conservative religious vendors that they disagree with. If liberal business people don't have to provide conservative religious goods or services that they find offensive, then the Masterpiece opinion says conservative believers don't have to do same-sex weddings that violate their conscience or that they find offensive. And this means that the Supreme Court has gone much further than is generally recognized towards protecting wedding vendors. And it has taken a substantial step towards the protective understanding of Employment Division versus Smith, that even one or a few secular exceptions make a law not neutral or not generally applicable. If the law is not neutral or not generally applicable, religious conscience objectors are entitled to an exemption unless there is a compelling government interest in requiring them to comply, and the state's willingness to grant secular exemptions seriously undermines any claim to a compelling interest in enforcing the law without exceptions. Kathleen sort of hinted that I would talk about whether the dignitary interest on the same-sex couple side is a compelling interest. Obviously, my focus is elsewhere tonight, but very briefly, there is a lot of First Amendment law, a lot of free speech law that says the fact that you give somebody deep offense is not a compelling reason to suppress your speech or limit your speech. It's no more compelling in this context. The dignitary harm to the couple is real. The dignitary harm to the baker whose conscience is overridden is also real, and I think, in fact, greater. It's a one-time event for the couple, For the baker, it is surrender your conscience permanently or surrender a large part of your business or your occupation permanently. So I don't think there's a compelling interest here, but it is also settled law that if the state doesn't treat its own interests as compelling, if it allows other exceptions, then that's pretty good evidence that its claimed interest is not compelling. So I've outlined a requirement to treat claims consistently on both sides of this debate, but that requirement will be powerful only if the courts take it seriously. States will try to manipulate their rules to justify unequal treatment of the objectors they agree with and the objectors they don't. And in Masterpiece itself, 4 justices accepted such a manipulation. Justice Kagan's concurrence, there are actually 7 votes for the majority, Justice Kagan's concurrence and Justice Ginsburg's dissent both argued that the state's discrimination could have been justified on the ground that the protected bakers would not sell an anti-gay cake to anybody, but Phillips would sell wedding cakes to opposite-sex couples. But as Justice Gorsuch's concurrence explained, this argument reaches the preordained result only by manipulating the level of generality. It treats the anti-gay cake as having a distinctive message, but the pro-gay cake, the cake for the same-sex wedding, is merely generic. If the anti-gay cake is a unique product because of its message, then the category is not cakes or wedding cakes, but cakes with a particular message. And as I said before, often a cake for a same-sex wedding will have some indication, even if only symbolic, indicating approval of the marriage, 2 brides, the couple's names, a rainbow, whatever. That is a cake that Jack Phillips would not sell to anybody. Even without such symbols, the cake still sends a celebratory message. Here's another way to think about that same point. The attempt to rationalize what Colorado did treats an anti-gay cake and a gay pride cake as 2 different products. And the protected bakers wouldn't make one of those products for anybody. But it treats the same-sex wedding cake and the opposite-sex wedding cake as the same product, distinguished not by their different messages, but only by the identity of the customer. We come back to the same basic contradiction. The Colorado courts and the justices of no separate opinions treat Jack Phillips as making a decision about the customer, but the protected bakers as making a decision about the message. Now, Colorado and at least some gay activists remain determined to get Jack Phillips. He reports that his store has been vandalized, he's received death threats, countless hateful phone calls and emails, and he's received repeated requests for cakes that the purported customer knows he will not make. Cakes honoring Satan have been a very popular order, and one such test order came, not coincidentally, on the day the Supreme Court agreed to hear his case. It would not have served the tester's purpose to ask for a wedding cake, because to avoid further penalties, Phillips was no longer making wedding cakes for anybody. He gave up 40% of his business and 40% of his income and laid off nearly all his employees to follow his conscience. And the person ordering knew all this. She is a lawyer who reports on her website that she takes great pride in suing businesses that discriminate against the LGBT community. So she asked for a cake that was blue on the outside and pink on the inside, and was careful to tell him that it was to celebrate her gender transition. Phillips said he could not make that cake. She filed a complaint with the Civil Rights Commission, which is why we know her identity. And 3 weeks after the Supreme Court's opinion, the commission's director found probable cause to believe there had been a new violation. This new case is a step beyond the Supreme Court's decision in one way that seems important to me. It does not involve a wedding. It is not a religious context. I think that Phillips should still be protected, but for me, it's a somewhat harder case. It may be no harder for the court because the court opinion in Masterpiece made nothing of the fact that Phillips understands weddings as religious events. The gender transition cake is still a demand that Phillips commit his talents to celebrating something deeply at odds with his religious faith, and his claim of conscience is still narrowly focused on a particular celebration. Narrow focus goes to the argument about compelling government interest. An exemption for merchants who refuse to serve gays or transgender persons at all, or in a wide range of transactions, would inflict much more harm on the LGBT community. It would threaten frequent denials of service instead of very occasional denials in a few religiously sensitive situations. An exemption for celebrating gender transitions would not threaten widespread refusals of goods or services to transgender persons. So I do not think that the state's interest in this narrowly focused claim is yet compelling. And enforcement of the Colorado law is still discriminatory. Colorado has not abandoned or repudiated the position it took in the William Jack cases. It is apparently still the state's position that secular bakers with views the state agrees with do not have to make cakes that they find offensive, but conservative religious bakers with views the state disagrees with do have to make cakes that they find offensive. So the law is still not generally applicable, in my view. It is still administered with hostility to religion, and so is not neutral in the Supreme Court's view. Either way, the compelling interest test still applies. If the Colorado courts enter another order against Jack Phillips, there will be another petition to the Supreme Court. Justice Kennedy will no longer be there. Who will be? Probably Justice Kavanaugh or some similar justice who the Republicans rammed through in the lame duck session would be my guess. With Kennedy's retirement, there is no one left from the court that decided Employment Division versus Smith. There has been a generational transition in the conservative legal movement. The modern conservative legal movement began in reaction to what it perceived as the activism of the Warren Court. It emphasized deference to the political branches, and that was the theme of the Smith opinion. Scalia was devout. He wasn't hostile to religion. He was hostile to the judicial balancing of interest inherent in the compelling government interest test. Better that small religions be disadvantaged, he said, than that judges balance the believer's interest in every religious practice against the government's need to regulate that practice. Scalia plainly envisioned that the victims of his decision would be small religions and idiosyncratic religious practices. He did not foresee that our largest religious minorities, his religion, would need the protections of religious liberty for moral teachings of great importance to them. Both of those things have changed. Today's conservative judges are as activist as the Warren Court ever was. Decades in the judicial majority can lead you to believe that judicial activism is a good thing. If you have the power, you eventually decide you ought to use it. And in the highly visible culture war cases, the victimized religions today are conservative Christians, Catholics and evangelicals most frequently, Mormons, fewer cases simply because there are fewer people. But traditional religions with traditional conservative religious views are the typical victims in the culture war cases. The court's conservatives have vigorously enforced the Federal Religious Freedom Restoration Act, most notably in the contraception cases. And if Masterpiece returns to the court in the carefully contrived case of the gender transition cake, the conservatives, I think, are likely to see the persecution of Jack Phillips, a concerted effort to force him to surrender his faith or his business. I think they will want to protect him with a clear rule that states cannot misinterpret or evade. Some religious conservatives look forward to Smith being overruled, and that could happen. But Masterpiece points the way to what I think is more likely. The court will build up the protective part of Employment Division versus Smith, the requirement that laws burdening religion actually be entirely neutral and generally applicable. Any secular exception that undermines the interest offered to justify regulation of religion will show both that the law is not generally applicable and that it serves no compelling interest. Such an exception may be written into the law, or it may emerge as a matter of interpretation. It may be labeled as an exception, or as a gap in coverage, or as a claim that one side simply didn't violate the law and the other side did. But if there is a secular practice and a religious practice that each undermine the same alleged governmental interest, and the religious practice is regulated and the secular practice isn't, I think the court is likely to say that's not generally applicable. That is certainly the implication of Masterpiece Cakeshop. Masterpiece gets most of the way there, but its emphasis on the state's hostility to Phillips's faith did it the hard way. It means those working to minimize the holding can still read it as a motive case, and judges are notoriously reluctant to find that state officials acted with bad motive. But in Masterpiece, the hostility was inferred from objectively unequal treatment of Phillips and the other bakers. There's a very short step to make that focus on objectively unequal treatment even more explicit, and to make objectively unequal treatment dispositive whether or not the fact finder draws an inference of actual hostility. Colorado may soon provide the opportunity for the court to say all that. This would lead to much better protection for religious liberty, and that would be a good thing, not just for religious wedding vendors, but for a broad range of cases. Do not assume that this battle over legal doctrine is only about abortion, contraception, and same-sex weddings. The culture war cases grow out of deep moral disagreement about matters relating to sex, and they get all the headlines, but they are not the typical cases. The typical case about religious exemptions in the lower courts involves Sabbath observance, grooming rules, Amish buggies, unnecessary autopsies, churches feeding the homeless, getting the neighbors riled up, or some other random conflict between pervasive regulation and diverse religious practices. They mostly do involve the small religious minorities that Justice Scalia thought he was putting at risk in Smith. And then there's Mary Steinmetz, the Kansas woman who died for her faith in America in the 21st century. She was a Jehovah's Witness, so she could not accept a blood transfusion, and she needed a liver transplant. Bloodless liver transplants were available in Omaha, and they were actually cheaper than any transplant hospital in Kansas. But Kansas Medicaid had a rule. We don't pay for out-of-state medical care. She sued under the state constitution, and she eventually won, but by then it was too late. Her medical condition had deteriorated, and she was no longer medically eligible for a transplant. She died soon thereafter. Religious liberty reduces human suffering. It reduces social conflict. I don't need to explain this to an audience mostly of Mormons. It is one of America's great contributions to the world. We should not let it slip away either in legal wrangling or in a bitter culture war. And the Supreme Court's opinion of Masterpiece is an important step toward restoring federal constitutional protection for religious liberty. Thank you for listening. I'll be happy to take questions. I'm told there are microphones circulating and index cards for the introverts. Yes, sir.
As a graduate student in Vienna, I earnestly advocated the view that the United States had no established religion. And I was countered with, but you do. The old order Amish are for you an established religion. Could you speak to the proposition that the state arguably has no entitlement to deprive a child of a uniformly mandated education because of parental objections to the child's education?
Well, I think Wisconsin versus Yoder and the Amish going to high school was a hard case. It's a close issue on compelling government interest. And to the people in this room, it is unimaginable that you would end your formal education at 8th grade. It is equally unimaginable you would end your formal education at 10th grade. And that was what the argument was about. Wisconsin didn't want much. So you had to go to school until you were 16, which is about, typically falls in the middle of 10th grade and about an extra year or year and a half, at the most 2 years, beyond what the Amish were willing to do. And Wisconsin had no coherent theory of why that extra year and a half mattered. The age 16 was picked as a matter of labor regulation. It never had any basis in education policy. And so the Supreme Court said there's no compelling interest in that extra year and a half. It was also, in the court's view, not the case that the Amish children got no education after 8th grade. Rather, they would get vocational education on the farm. I think Yoder is clearly right in saying the government should have to have a compelling interest before it puts a serious burden on a small religious minority. I think it's a close case on compelling interest, but given what Wisconsin was demanding, I think the court probably got it right. Let me say just a word about your debates in Vienna. Government does not establish a religion by leaving it alone. Exemptions for religious minorities do not establish those minorities. They protect them from government regulation imposed by a larger majority that outvotes them. But that argument is out there. There are plenty of people prepared to argue that religious exemptions establish a church. I think that's just silly, and there's absolutely no basis for it in the original understanding of the Establishment Clause. Exemptions emerged very early in our history as a matter of free exercise. They were never thought to be part of the establishment. Who else? Yes, ma'am. Okay.
Let me stand for. So I'm associated with Christian colleges and universities, and
Great.
one of the things that Masterpiece said was that the court was going to balance religious liberty views with LGBT views. And actually, in some of the cases, it said, can the legislature do something about actually laying out exemptions and laying out LGBT civil rights like they did with the Utah Compromise? And we saw the opposite in the Trinity Western case, where it went all the way up to the Supreme Court. It was not allowed to open a law school, and then people said, well, we should go to the legislature. So what is the advantage of legislative drafting in order to make this more predictable around exemptions and civil rights?
Did people hear that question? So can the legislature solve this? And there was a reference to Trinity Western. Before you all panic, that's a Canadian case. Trinity Western is an evangelical law school, and the bar authorities have been for years trying to deny it accreditation because it has a chastity policy for students and faculty, and the bar authorities just won in the Supreme Court of Canada. So yeah, in many ways it would be much better if legislatures would solve this. Every state that includes gay rights in its employment discrimination laws has a religious exemption, usually just for religious organizations, not for-profit businesses. But in the early years, this could be solved legislatively. It can't be solved that way anymore, in part because we're too polarized, in part because the gay rights side is making the classic Puritan mistake, right? When they were oppressed, and undoubtedly they were, we treated them very badly. When they were oppressed, all they asked for was equality and liberty. But now that they're winning, they no longer want any religious exemptions. And so we have not quite half the states with gay rights laws, many of them with some kind of religious exemption. All the states that enacted same-sex marriage legislatively included religious exemptions. And we have a little more than half the states with no gay rights law and no prospect of enacting any because they're not willing to include a religious exemption. Utah is the shining example here, which enacted a statewide gay rights law for employment and for housing, not for public accommodations. They didn't solve the whole problem. But for employment and for housing, it's a gay rights law in Utah with strong religious exemptions. And it was immediately denounced by both sides and said not to be a model anywhere. The bottom line in most legislatures is the Republicans don't want the gay rights law and the Democrats don't want the religious exemption, and neither side will give, and they'd rather have no bill at all than a bill that includes provisions they oppose. And Alliance Defending Freedom, which has done a lot of good work and represented Jack Phillips and Masterpiece Cakeshop, is going around the country aggressively opposing any kind of compromise bill. And there are people on the gay rights side aggressively opposing any kind of compromise bill. So it's right now we're gridlocked. You've heard that before on many issues. So they're very hard to enact. The advantage of a legislative solution, if it could be negotiated, is both sides could know what they were getting, right? They could draft in fairly specific terms who is exempt, who is not, at what point. If you have 10 employees, do you lose your exemption? If you have 20, do you lose your exemption? That's a number that can be negotiated. Neither side would have to worry about judges interpreting general language in a way that turned out to be deeply hostile to them. But it's very hard to get from here to there, and probably the events of this week are making it even harder. I got a couple of written questions. Please comment on Justice Thomas's concurrence. What is the core of his argument? I don't know. Did Thomas write a separate concurrence? Yes, I'm sorry. It's just gone from my head. I apologize. If you want to email, whoever wrote that question, if you email me, dlaycock@virginia.edu, I'll actually look at Justice Thomas's concurrence and give you an answer. In your preface, you gave your views on same-sex marriage as a policy view only. Was Obergefell rightly decided? Explain. It started out as a policy view, became a constitutional view. I think what happened in Obergefell is, and the court's always been more implicit about this than explicit, but it's the court's view is, and I think it's right, the only reason for prohibiting something is religious disapproval. That's not a reason the state can act on. It has to have some reason in addition to that. And the states in Obergefell struggled mightily to come up with some reason that made sense. And they weren't having any luck, right? I mean, the court's opinion says, it's got a whole string of adjectives. The state's argument is implausible and ridiculous and attenuated and so forth. At the end of the day, the state's argument came down to the reason states recognize and regulate marriage has nothing to do with love and mutual commitment. That is irrelevant to us. The only reason we recognize and regulate marriage is so that when the love and commitment wears out, but in the meantime there have been children, you'll be more likely to stay together. Because marriage is only about reproduction. Well, that's not how I've experienced my marriage of 47 years. I love my kids, but been a lot more to our marriage than that. So yeah, I do think Obergefell was rightly decided. But if you're an originalist, if you say, what did the framers think about? They obviously never imagined this in their wildest dreams, right? And so you can see why it was 5-4 and why the dissents were impassioned. Will church-sponsored colleges and universities that forbid students and faculty to enter into same-sex relationships be able to retain their tax-exempt status? I think so. There was, 1983, there's a decision, Bob Jones University of the United States. Bob Jones is in South Carolina, founded by segregationists. By the 80s, it was admitting African-American students, but still had a rule, no interracial dating. And any interracial couple or any student who dated someone of a different race outside the student body could be expelled. And the Supreme Court took their tax exemption away, and they said an organization acting in defiance of fundamental public policy is not a charitable organization. And so the fear is, will that precedent be extended to single-sex colleges, to colleges that take a traditional position on same-sex relationships, to Baylor and Brigham Young and Pepperdine and Notre Dame? Are they all in danger? The important thing to note is Bob Jones hasn't been extended to anybody or anything. It is a one train only about race. This is a very controversial proposition, but I think that makes sense. I think race is constitutionally unique in our history. No other victimized group ever required a civil war, 750,000 deaths, 3 constitutional amendments, and 150 years of struggle trying to enforce those amendments to address their problems. The Supreme Court has not said that, but it has confined Bob Jones to race. There may be a time in 50 years if resistance to same-sex marriage becomes as disreputable as racial segregation is today, maybe, but I don't think tax exemptions are in danger. Now, the Solicitor General of the United States, who should have known better, got that question or oral argument and said, gee, Judge, I'd have to think about it, but that'll certainly be an issue, which understandably panicked a lot of people. I don't think any government's going to move on that front anytime soon. That's my prediction. Yes, sir.
I recently got an email urging the Virginia General Assembly to pass the ERA amendment. Do you have any comments on that?
Well, the Equal Rights Amendment was proposed in 1972, I think. Quickly got nearly the 38 required ratifications, then it stalled. There was a time limit on it. The time limit ran out 30 or more years ago. Some state just ratified it, and there's an argument being made that the time limit is unconstitutional, and no state is permitted to reverse its ratification. It's a ratchet. I don't think that argument's going anywhere. And the short answer is, if they ratify the Equal Rights Amendment, the time limit will be part of the Constitution, which makes it very hard for it to be unconstitutional. That's my short answer. Who else? All the way in the back.
Hey, Doug, you know me.
I'm
It's
sure
Carolyn
I know you.
Hom-
You
it's
sound familiar, but you're a long ways away.
Okay, it's Carolyn Homer at CARE.
Carolyn.
Hey, so I work for the Council on American Islamic Relations, and our overwhelming sentiment after Masterpiece was that if government explicit hostility to religion is a constitutional harm, then the Muslim ban decision is unacceptable.
Right.
And I'm just kind of curious as to your reaction on that argument.
Well, see, you're assuming, and maybe I was assuming in my talk tonight, that the Supreme Court acts on principle. And as I tell my students, I tell them in constitutional law, don't get too cynical. All you have to really believe is some of the judges, some of the time, to some extent, act in good faith and on principle. When principally but not exclusively. When Masterpiece came out, I think you guys said, law professors all the country said, if they mean this, it's toast for the travel ban. But no one expected them to really mean it, and of course, they didn't. And what's most embarrassing is both the liberals and the conservatives flipped sides, right? The conservatives who weren't worried about hostility to Jack Phillips were very worried about Trump being hostile to anybody, and the conservatives who put together the majority to protect Jack Phillips were quite happy to let President Trump express hostility and exclude Muslim people from Muslim countries. It was immigration, which is there's a tradition of extreme deference to the executive branch, where the national security argument, there's deference there. There are reasons to understand why they did it, but yeah, it was inconsistent. It clearly was. Who else? Yes, sir. Okay, I just got told one more, so.
So your litigation strategy after Smith, right, is to expand the definition of laws that aren't generally applicable by finding any kind of exemption from those laws. And I'm wondering if you can speak to the issue that creates an incentive, right, for a legislature that wants to pass a challenge-proof law to not give any exemptions, right?
Right.
And so to the extent that you think it's kind of unhealthy for us to be resolving all these big, highly culturally salient issues in front of the Supreme Court, instead of hammering them out through a series of sort of ad hoc legislative compromises, it seems that your strategy is creating an incentive to not do that which would be more politically healthy.
There's force to that. So why not just ask the Supreme Court to overrule Smith? Well, they've been asked. It is much easier for them to undermine a precedent than it is to flat out overrule it. And you see that all the time. For the people who are worried about Roe v. Wade, they're not going to overrule it. They're going to find that nothing ever is a substantial burden on the right to choose. The second problem is you only get 15,000 words. That sounds like a lot, but it goes in a hurry. You don't have the words to make a full argument about why, even with Smith, you should win because this law isn't generally applicable, and to also make a full argument about why Smith was wrong and why it should be overruled. You've got to choose. And so far, every litigant who's gotten up there with a case has decided the choice was distinguish Smith. That's a stronger bet, a better bet than asking them to overrule it. That does, to some extent, have the political effect you worried about, that it pushes legislators towards all or nothing solutions. It's probably not as bad as your comment suggested, and here's why. If legislature enacts a religious exemption that is only, let me give you a real example instead of a hypothetical. The early version of the contraception rules under Obamacare said only the church itself and orders of nuns basically are exempt. All the other religious nonprofits have to provide contraception. Well, that was bad policy. And it violated the Religious Freedom Restoration Act because it burdened these religious nonprofits without having a compelling reason. But it didn't fail the test of general applicability because it wasn't a secular exception. It was a rule that said, okay, we're going to compromise here by exempting the core of religion, the most intensely religious organizations, and not more marginal religious organizations. There were people arguing that even that was unconstitutional, and I think that was a suicidal argument. That really would have made it impossible for any legislature to ever enact any kind of religious exemption, because the threat would have been, if you enact even a little bitty one, it's going to be expanded to cover the universe. And the court didn't buy that argument, and clearly, they said a little bit about it at the opinion, but clearly at the oral argument, they were all deeply suspicious and hostile to that argument. So I think it's still possible to do exemptions legislatively that compromise in some way. What the legislature can't do is provide secular exceptions that are religious, or provide religious exceptions that discriminate, right? Can't say Catholics are exempt but Protestants aren't, or vice versa. There are restrictions on what the legislature can do, but it still has room to compromise here. So you point to a risk, but I don't think it's an insoluble risk. I'm told that was the last question. I'll be around for a while if people want to come up individually.